I heard there's a point that is really the way to do it.
Senate will please come to order. Today's devotionals will be a moment of silence. Thank you. Are there any announcements? Senator from Chittenden Central.
Thank you, Mr. President. A word on Proposition 1. We have lingering questions from senators about the proposition. Having talked about it in several forums over the last week or two, it seemed to us that it could benefit from additional testimony, additional committee work in the Judiciary Committee. So I have spoken with the Chair of Judiciary and the Chair of Government Operations about moving proposition to the Judiciary Committee. So over the next week, week and a half, we could take additional testimony. Folks wanted to be reassured, for instance, that there weren't other constitutional avenues besides amending the Constitution. So with the Senate's help, I hope to suspend the rules and move Proposition 1 from our action calendar to the Judiciary Committee with the Government Operations Report intact. So if I might just formalize that, I would move that at this time the Senate suspend its rules and commit Proposition 1 to the Committee on Judiciary with the report of the Government Operations Committee intact. Thank you, Mr. President.
Now, the senator from Chittenden Central has moved that the Senate suspend its rules in order to commit Proposition 1 to the Committee on Judiciary with the report of the Committee on Government Operations. So, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes have it, and you have committed Proposition 1 to the Committee on Judiciary with the report of the Committee on Government Operations. We have one gubernatorial appointment to refer. The governor has appointed Edward M. McNamara of Montpelier as the chair of the Public Utilities Commission for the I don't know which committee it goes to. It goes to the Committee on Finance. So the Committee on Senate Finance will receive that. We have a House resolution, Joint Resolution 9.
Chair H9, joint resolution authorizing the Green Mountain Boys State Educational Program to use the State House facilities on June 27, 2024.
Now you've heard the reading of the resolution, and it'll be placed on the calendar for action on the next legislative day. We have a Senate bill or two Senate bills. First being S305 introduced by the Committee on
S305, an act relating to miscellaneous changes related to the Public Utility Commission.
They've heard the first reading of the bill. Will be put on the notice calendar on tomorrow's calendar. We have S306, also introduced by the Committee on Applications and Energy.
S306, an act relating to changes to the Clean Heat Standard.
Now you've heard the first reading of the bill is referred to the calendar action for notice. We have S307, also introduced by the Committee on
S307, an act relating to the use of administrative use controls at contaminated sites.
Now you've heard the first reading of the bill. It too will be placed on the calendar for notice. We have S308, bedtime reading here, introduced by the Committee on Natural Resources and Energy. Bill by title.
S308, an act relating to updates to land use planning.
Now you've heard the first reading of the bill. It too will be placed on the calendar for notice. We have a couple of House bills for reference. The first being H603. It passed the House on January 26th. Bill by title.
H603, an act relating to the poultry slaughter exception to inspection.
Now, you've heard the first reading of the bill is referred to Committee on Agriculture, and we have H 839. It passed the House on January 26th. This is in the first reading by title.
H 839, an act relating to fiscal year 2024 budget adjustments.
Now, you've heard the first reading of the bill is referred to Committee on Appropriations. That brings us to the order of the day. We have S 190, an act relating to statements made by a child victim of an offense involving serious bodily injury. Please listen to the second reading of the bill.
S 190, an act relating to statements made by a child victim of an offense involving serious bodily injury.
Now, you've heard the second reading of the bill. For the report of the Committee on Judiciary, the senator from Franklin County, Senator Hills.
Thank you, Mr. President. Full disclosure, while they're passing out a copy of the bill, I'm not an attorney. I'm not pretend to be one, but I have a couple of capable attorneys on standby for me, just in case. On to the bill, S 190. The purpose of S 190 is to limit the number of times a child must recount their experience of physical abuse that resulted in serious bodily injury. The bill amends the court rules, not statute. While the General Assembly does not do so with regularity, it is clear that we do have the authority to do so under 12 VSA Chapter 1. Section 1. This section amends the Vermont Rules of Criminal Procedure with respect to depositions. A deposition involves the taking of a sworn, out-of-court oral testimony of a witness that may be reduced to a written transcript for later use in court or for discovery purposes. Discovery means investigating the evidence that the other side plans to present. Currently, there are special rules regarding depositions of children under the age of 16 if they're victims of certain sexual offenses. S 190 extends those protections to children under 16 years of age if they are victims in a case of cruelty to a child involving serious bodily injury. For reference, cruelty to a child, 13 VSA 1304A, a person over 16 years of age having the custody, charge, or care of a child who willfully assaults, ill-treats, neglects, or abandons or exposes such child, or causes or procures such child to be assaulted, ill-treated, neglected, abandoned, or exposed in a manner to cause such child unnecessary suffering or to endanger his or her health shall be in prison not more than 2 years or fined not more than $500 or both. Section B1, if the child suffers death or serious bodily injury as defined in subdivision 1021-2 of this title or is subjected to sexual conduct as defined in subdivision 2821-2 of this title, the person shall be in prison not more than 10 years or fined not more than $20,000 or both. The definition for those who are interested of serious bodily injury is 13 VSA 1021. Serious bodily injury means bodily injury that creates any of the following: a substantial risk of death, a substantial loss or impairment of the function or other bodily member or organ, a substantial impairment of health or substantial disfigurement, or strangulation by intentionally impeding normal breathing or circulation of the blood by applying pressure on the throat or neck or by blocking the nose or mouth of another person. Depositions in such cases are only to be taken up upon agreement of both parties or approval of the court under the following conditions. 1, the court finds that the testimony of the child is necessary to assist the trial. 2, the evidence sought is not reasonably available by any other means. And 3, that the probative value of the testimony outweighs the potential detriment of the child being deposed. If a deposition is taken, the court must appoint an attorney for the child and issue a protective order to protect the child from emotional harm, unnecessary annoyance, embarrassment, oppression, invasion of privacy, or undue burden of expense or waste of time. Section 2, this section amends the Vermont Rules of Evidence with respect to admissibility of hearsay. Hearsay is an out-of-court statement offered as evidence to prove the truth of whatever is asserted. Think of it as secondhand evidence. Because the person being quoted is not present, it makes determining the credibility of that statement difficult. Thus, hearsay evidence is usually not admissible. However, court rules provide circumstances where hearsay evidence can be entered into evidence. Rule 804A, the Vermont Rules of Evidence, which is being amended in Section 2 of this bill, currently permits hearsay statements by a child 12 years of age or under if the child is the punitive victim of sexual assault. S-190 extends that admissibility to hearsay statements by a child 12 years of age or under if the child is the punitive victim of a cruelty to a child involving serious bodily injury. To assure credibility, the statement must not be made in preparation for a legal proceeding, and if a criminal or delinquency proceeding has been initiated, the statements must have been made prior to the defendant's initial appearance before a judicial officer. The child must be available to testify in court, and the time, content, and circumstances of the statement must provide substantial indicia of trustworthiness. The effect takes, this act takes effect on 7/1/24. And with your permission, Mr. President, I'd like to read a letter of support from 12 different victim advocacy agencies throughout the state of Vermont.
You may.
Protection through hearsay exceptions, limitations, and depositions on children who are sexually abused were established in Vermont over 15 years ago. Those protections result in better outcomes, including treatment for offenders and safety for victims, without inflicting further trauma on the child by requiring them to tell their story repeatedly to strangers working in the system. Those same outcomes are not realized in physical abuse cases, which are often not charged or reduced or are dismissed due to avoid inflicting trauma upon children. Several examples of cases where a child experienced serious bodily injury abuse were shared with our committee. Despite experiencing numerous serious injuries, these cases had to be dismissed before the caretaker for the child ultimately refused to subject their 4, 5, and 6-year-olds to go to depositions where they would be also cross-examined. Many states have updated their protections to extend to child victims of physical abuse. Vermont has established special investigation units in statute, mandating these units specifically investigate and respond to cases of sexual abuse and serious physical abuse of a child. Currently, our narrow protections provide 2 different sets of tools for investigators and prosecutors to utilize to address these incidents. The difference is based upon the false presumption that sexual abuse is necessarily more traumatizing than being seriously physically abused. The presumption has been undermined in study after study about both the short-term and long-term effects of physical abuse. While historically most of the caseload of the SIUs has consisted of sexual abuse of child, alarmingly the units are noting a significant increase in cases involving serious bodily injury of a child. Children who are both sexually abused and physically abused are afforded a forensic interview by trained investigators at the special investigation units prior to any being filed. The interview followed the same guidelines and adhered to nationally accredited standards regardless of the type of abuse suffered. Those interviewed are audio and video recorded and are made available to the defense through discovery. The process for physical abuse changes once the case is charged, resulting in a denial of protection for these children and a lack of accountability for the person causing the harm. These protections and accommodations for them are long overdue. I would list all 12, but I don't think it's necessary. They range from the Vermont Victim Centers to Vermont Network Against Domestic Violence, so on and so forth. We heard from Legislative Counsel, Deputy Defender General, Juvenile Defender, Defender General's Office, Victims Advocate, Windsor County State's Attorney, the Executive Director, Center for Crime Victim Services, the Executive Director, Windham County Special Services, Unit Child Advocacy Center, Deputy Director, Vermont Network Against Domestic and Sexual Violence, Deputy State's Attorney, Franklin County, Victim Advocate, Franklin County, and Northwest Unit Special Investigation, Chief Superior Judge, Vermont Judiciary. The bill came out of your Senate Judiciary 500, and we asked for this Senate support. Thank you.
There now is an amendment to be offered to the committee report by the senator from Chittenden Central.
Mr. President, the amendment is a straightforward amendment that is supported by both the Center for Crime Victim Services and the Defender General's Office. The amendment requires that the forensic interviews in question be recorded in order to be used in the manner that is proposed in the bill. We took testimony that this is already common practice and it makes sense to memorialize it in the law. It would also allow for greater transparency and accountability about the quality of the evidence to be introduced as hearsay. The committee vote was 5-0-0, and we asked for the body's support in amending the bill.
So the question currently is, shall the Senate adopt the report of the Committee on Judiciary with the amendment offered by the senator from Clinton Central? Are you ready? I will restate the question through some confusion. Shall the Senate adopt the report of the, amend the report of the Committee on Judiciary as offered by the senator from Central as found on page 125? Are you ready for the question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. Guys have it, and you have amended the report. of the Committee on Judiciary. The question now is shall the bill be amended as offered by the Committee on Judiciary as amended? Are you ready for that question? Senator from Huntington.
President, this is our first bill out of Senate Judiciary. I'm very happy that the committee came together on this bill, but Saturday, I had the opportunity to meet in Manchester with a group from the St. Joseph's Orphanage who are building a memorial. And I actually met somebody that testified in our committee on changing the criminal law regarding sexual abuse and the statute of limitations on serious bodily abuse. And actually got to meet them in person because it was during COVID and we were all on Zoom. In conversations with her about her experience at St. Joseph's Orphanage is testament to why this type of bill is needed, unfortunately. And as the senator from Franklin mentioned, we're seeing an increase in child sexual and physical abuse, an alarming increase in physical abuse. So I'm very proud of the committee's work on this bill, and I hope the Senate will concur in passing this important piece of legislation. Thank you.
Question is, shall the Senate amend the bill as offered by the Committee on Judiciary as offered, as amended? Are you ready for the question? So all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. You guys have it, and you have amended the bill as offered by the Committee on Judiciary as amended. The question now is, shall the bill be read for that question? If so, all those in favor, please indicate by saying aye.
Aye.
Opposed indicate by saying nay. Guys have it, and you've ordered third reading of S 190.
Thank you, Mr. President. Pending announcements, I would move that the Senate stand in adjournment until Thursday, February 1st at 1 p.m.
I probably moved a little quickly. I should have asked you to pause on that. I believe there are a couple other persons to be made. Do you want to call that?
Mr. President, might I point out that this makes me look bad every day?
I believe I started with an apology, but yes, I take full responsibility.
Thank you. I will withdraw my motion. Thank you.
Senator from Washington.
Thank you, Mr. President. I move that the Committee on Transportation be relieved of S 187, an act relating to student application of sunscreen and car seat safety, and that the bill be committed to the Committee on Health and Welfare. And it is not a bill about the application of sunscreen on car seats. They're two separate issues. The Transportation Committee did deal with the car seat part, but we would like Health and Welfare to look at the application of sunscreen section of the bill.
Now, the senator from Washington has moved that the Committee on Transportation be relieved of S 187, an act relating to student applications of sunscreen and car seat safety, and that the bill be committed to the Committee on Health and Welfare. If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes have it, and you have relieved the Committee of Transportation of S 187 and referred to the Committee on Health and Welfare. Senator from Addison.
Thank you, Mr. President. Senate Natural Resources and Energy sent 4 committee bills to the floor today. Pending entry on the calendar for notice, I move that the following bills be referred to the Committee on Senate Natural Resources and Energy. They are S305, S306, S307, and S308.
Now, the senator from Addison has moved that pending entry on the calendar for notice that bills S305, calculating miscellaneous changes related to public utility commission, S306, calculating changes to the clean standard, S307, calculating the use of administrative use controls at designated sites, and S308, calculating to updates to land use planning, be referred to the Committee on Natural Resources and Energy. Are you ready for the question? If so, all those in favor, please indicate by saying aye. Aye. Those opposed indicate by saying nay. The ayes have it. And you have referred S305, 306, 307, 308 to the Committee on Natural Resources and Energy. Senator from Chittenden Central.
Thank you, Mr. President. Pending announcements, I would move that the Senate stand in adjournment until Thursday, February 1st at 1 p.m.
Are there any announcements? Senator from Washington.
Thank you, Mr. President. Senate Finance will meet at 1:30.
Senator from Addison.
Thank you, Mr. President. Senate Gov Ops will meet at 1:30.
Senator from Bennington.
Senate Education will meet 15 minutes after the fall together.
1:30.
Senator from Essex.
Thank you, Mr. President. Senate institutions will meet 15 minutes after the call gap.
Senator from Addison.
Senate Natural Resources and Energy will meet tomorrow morning at 9 a.m.
Senator from Chittenden Central.
Thank you, Mr. President. I had the great privilege of working with the Ukrainian American diaspora and the state curator to put together an art show in the cafeteria that's been there for the last month, celebrating the art, culture, and tradition of Ukraine. War often erases all of the beautiful things that come from a culture because they're rightly focused on the destruction and devastation. I have an even greater honor today to welcome the Ukrainian artists and collectors, as well as the larger Ukrainian diaspora here in Vermont, to a closing reception of that show from 4 to 5 in the cafeteria. And I hope that you will join us to celebrate some of the beauty that comes from my family's homeland. Thank you.
Senator from Windsor.
And after you celebrate all the beautiful things from the Ukraine that we've had the privilege of getting to observe for the last month, I would encourage you all to come and celebrate the end of January at Farmers Night tonight. We're doing, it should be a terrific evening and a memorable one, an evening of Tibetan music and dance. And it should just be terrific. I encourage you all to come, 7:30 in the House chamber.
Are there any further announcements? Seeing none, the senator from Chittenden Central has moved that the Senate stand in adjournment until Thursday, February 1st at 1 p.m. Are you ready for the question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes have it, and the Senate will stand in adjournment until Thursday, February 1st at 1 p.m.